It is with tremendous delight and excitement that I welcome you to this very special event as Ken Feinberg will talk with us about unconventional responses to unique catastrophes, tailoring the law to meet the challenges. This is given in conjunction with his appointment as the Stephen and Maureen Klinsky Professor of Practice for Leadership and Progress. And I want to give you a little bit of background about that, as I also give my personal thanks to Stephen and Maureen, who are here today. Stephen Klinsky is a graduate of the Harvard Law School, class of 1981. He's the CEO and managing director of New Mountain Capital, a firm he founded, and together with its business associates, the firm manages private equity, public equity, and credit capital. And previously, he was a co-founder of the leveraged buyout group of Goldman Sachs and a partner at Fortsman Little & Company. In 2013, Steve and Maureen endowed this professorship and actually, more importantly, endowed a vision. And the vision was to actually make it palpable and part of the life of the Harvard Law School to identify the pathways in the world pursued by leaders in many fields that are not the conventional ones that people think that a legal training opens up, to identify the ways in which legal training can help people inspire, address issues of public welfare, and broaden the ambit of opportunities that people think about. Our very first visitor under this framework was His Eminence Timothy Cardinal Dolan, who came because he likes the Klinskys. Basically, he wouldn't have responded to my call, but and he delivered an incredible and memorable lecture under this professorship. Other Klinsky professors have included Julius Janikowski, former chair of the Federal Communications Commission, former Congresswoman Jane Harman, and Chris Kelly, the first chief privacy officer and general counsel for Facebook. Now I get to talk about one of my favorite people on the planet, Ken Feinberg. Ken is the founder and managing partner of the Kenneth R. Feinberg PC, as well as the Stephen and Maureen Klinsky Professor of Practice here. And it's Professor of Practice, let's be clear, for leadership and progress. Nobody else in the world has that title. Feinberg developed an unusual career by becoming the consummate problem solver in the face of mass disasters, natural and man-made, identifying what models could be made, invented, replicated, or summoned out of whole cloth to deal with terrible, terrible circumstances. He probably is best known for serving as special master for the September 11th Victim Compensation Fund of 2001. In this role, he maneuvered it so excellently that he is widely known as the problem solver consummate all over the country and even in the world. This week, he was appointed special master to oversee a new fund to compensate victims of state-sponsored terrorism, including the bombings of American embassies in East Africa in 1998 and the bombings of the American embassy and Marine Corps barracks in Lebanon in the 1980s. As he did with the September 11th fund, Feinberg will reach out to all who qualify to file a claim, evaluate applications, determine appropriate compensation, give out awards, basically create whole cloth a system to deal with these terrible, terrible tragedies. He's also served as the fund administrator for the Hokie Spirit Memorial Fund following the tragic shootings at Virginia Tech. He was special master in the case of Agent Orange, dealing with charges about the exposures during the Vietnam War era. He has been special master in cases dealing with asbestos, wrongful death claims, Dalton Shield, and others. And in designing dispute systems, he's offered solutions in contexts including Hurricane Katrina and other Gulf hurricane contexts. He also served as the distribution agent for the AIG Fair Fund claimants. We can go on, and we're going to actually talk about some of these in our time here together. I do want to note that in his role also as an arbitrator, Ken Feinberg helped determine the fair market value of the original Zapruder film of the Kennedy assassinations, and also did something similar in addressing legal fees related to Holocaust slave labor litigation. He has served on presidential level commissions. He has taught at many law schools. He was named Lawyer of the Year by the National Law Journal. He's repeatedly identified as one of the most influential lawyers in America. And that is all without actually doing law practice, doing something that's really very, very different. And it's my great delight to welcome you all here to hear Ken Feinberg. And here is what we're going to do. He's going to talk for about 10 minutes. Then I'm going to interview him some. And then I'm going to ask you to continue the conversation. So, Ken, please.
Well, I want to thank the Dean for reading my resume. I must say I'm under a tremendous amount of pressure here today. Not only is the Dean sitting in during this, Steve and Maureen, with this incredible idea of funding programs to invite out-of-the-pocket legal thinking to come to the law school, and for them to be sitting in today. It's a great honor, frankly, to have them here today. But I'm also under a lot of pressure in the next 10 minutes because in the front row here, Sweet, Mnuchin, Goldberg, Rubenstein. Now, all three of these professors have in one way or the other directly or indirectly very much impacted my work. My work, whether it's ADR, torts, civil procedure and choice of laws and litigation, mass claims, these three professors have had a profound impact on what I do, and I know them well and I know their work. So I'm grateful that they are here today for a free lunch, for one thing, but that's all right. Now, in 10 minutes, I can sum up most of what I do very, very quickly. Every once in a while in American life, not often, there are tragedies. And the tragedies so overwhelm the American people. 9/11, Boston Marathon, BP oil spill, General Motors ignition switch failure, Volkswagen, Virginia Tech, Aurora, Colorado, the shootings in the movie theater. They so overwhelm and galvanize the American people that policymakers decide there ought to be a special program to compensate just these victims. Everybody else, fend for yourself. But for these victims, we want to do something special because the tragedy is special. 9/11 is the best example, you see. 13 days after the 9/11 attacks, Congress passed a law. And the law said anybody who doesn't want to litigate against the World Trade Center, the airlines, Boeing, the security guard companies, Massport, anybody who would rather go into a special funded program, funded by the taxpayer, you can do so. You don't have to, but if you want to, you can. Well, practically everybody came into that fund. 97% of all the families that lost a loved one on 9/11 came into the fund. We paid out taxpayer money, $7.1 billion. BP oil spill in the Gulf. BP puts up $20 billion, fronts it, and we pay out, with John Goldberg's help, we paid out about 225,000 people in businesses and got releases. In GM, the ignition switch, we paid out $600 million in about a year to about 300 deaths and physical injuries caused by the switch, which gave rise to automobile accidents. So every once in a while. Now, just a couple of points about programs like this. First, make a distinction between BP, 9/11, and GM, and the one fund Boston Marathon and Virginia Tech and Aurora, Colorado, or Sandy Hook Elementary School in Connecticut. You're all lawyers. There's a big difference between telling people we'll give you money and you will sign a release that you will not sue. And all these other programs like Marathon, it's a gift. Donated by the American people, they send in money and we distribute the money. No one signs a release. True alternatives to the tort system implicate the work of Goldberg and Rubenstein. The Boston Marathon and other charitable contributions implicate the work of Mnuchin in getting people to agree to take the money. Big difference. Who wouldn't take gift money? As opposed to, wait a minute, I better evaluate, am I better off litigating and going for a pot of gold, or do I take what Feinberg is offering and take that money now? Well, virtually everybody takes the money because the money is generous enough so that you're like Santa Claus giving this money out, you see. And people, 92% of the BP oil spill victims took it, 97% of 9/11, 95% of the eligible claimants took it in GM. So that's point number one. Big distinction conceptually between two types of programs. Second, it's hard to do this work in designing the program if you're not a lawyer. Now, you don't have to be a lawyer once the program's designed. In fact, once the program's designed and you're meeting with people, Mnuchin kicks in. You'd be better off going to divinity school or have a degree in psychiatry because you're dealing with individual vulnerable people. And it's a horror. It's debilitating. But designing the program, especially alternatives to the tort system, you better have studied with Rubenstein and Goldberg, because if you don't know tort 1 and civil procedure, you're in trouble when it comes drafting programs with methodologies and rules that are first cousins or more to tort and civil procedure. Who's eligible? What's the methodology for calculating damages? Well, if it's an alternative to the tort system, it's economic loss and pain and suffering and, a final exam in tort 1. You can't move without knowing that stuff. But once you get the program in place, other disciplines kick in, including empathy, psychiatry, sensitivity, qualities and characteristics that aren't always associated with our profession. But they're very, very important, you see. Now, the other sort of preliminary point before we go to Q&A, the other preliminary point is a very fundamental question. Forget the private programs where there's donated money. Never underestimate the charitable impulse of the American people. Those private programs, like the Boston Marathon, if people want to contribute to a fund and feel good about helping victims, hey, fine. What, are you going to pass a law prohibiting that? Of course not. But when you talk about programs like 9/11, BP, GM, now Volkswagen, that are true alternatives to the tort system, ask yourself whether, as a matter of political science, not law, as a matter of public policy, programs like that are a good idea or not. You should have read some of the emails I got when I was administering the 9/11 fund. Dear Mr. Feinberg, my son died in Oklahoma City. Where's my check? Dear Mr. Feinberg, I don't get it. My daughter died in the basement of the World Trade Center in the original 1993 attacks committed by the very same type of people. Why aren't I eligible? And it's not just terrorism. Dear Mr. Feinberg, last year my wife saved 3 little girls from drowning in the Mississippi River, and then she drowned a heroine. Where's my check? You better be careful. You set up these programs for a select few people. Everybody else, fend for yourself. 9/11, you will never see that program again. That program was a one-off response to a unique catastrophe in American history. It was the right thing to do. It really was. I think you can defend that 9/11 fund. I have. Don't ever do it again. Taxpayer money to help just these victims. Everybody else, you're not eligible. It's tough. There's a real political science question that accompanies programs established as alternatives to the tort system, to litigation. And I'm not sure it is so sound to delegate all of this responsibility to one person with unfettered discretion just to help these people, and everybody else, you're out of luck. BP oil spill, we'll pay you. Exxon Valdez, we won't pay you. So it's a real problem. It's a real problem. And, you know, if some of you are fortunate enough to be taking my reading class this semester, where we're studying my book, well, then you know exactly what we're talking about. So there's 10 minutes, and I turn it over to the dean.
That was great. You really have invented something that is incredibly unique and important, and the distinctions that you've drawn, we're going to talk about. I want to ask you to start with, even if we confine ourselves to the funds that you have worked with that are alternatives to the tort system, there are tough choices. There are choices about whether to mimic the damage calculations based on people's expected earnings, because doesn't that value lives differently depending on what kind of jobs they had? How have you approached those kinds of questions?
What are you going to have to do to get people to waive their right to go into the tort system? The minute you tie a program at the hip of the tort system, claimant, come into the Feinberg program or go the Goldberg-Rubenstein tort route. That's your choice. Now, it's pretty clear if you want to voluntarily attract people into this program, which is what policymakers want me to do. Well, you've got to give everybody a different amount of money. The banker, the stockbroker, the hedge fund manager. In the World Trade Center, you've got to give them more money than the waiter, the busboy, the cop, the fireman, the soldier. They made more. And if you want them to waive their right to sue, inevitably on day one, you know, you're going to create divisiveness. Guaranteed. Because you see, unlike the tort system where there's one claimant, one plaintiff suing, a car accident, she fell off a ladder, a slip and fall. In 9/11, I've got thousands of victims, and everybody counts other people's money. Everybody. It's human nature. So it becomes very, very tense and very, very divisive.
So in some of your experiences, you have not mimicked the tort system.
Well, we don't mimic the tort system if I can think of a way legally, as a lawyer, to avoid some of the tension in the tort system. Pain and suffering. If you think after 9/11 I'm going to calibrate different pain and suffering for every victim, forget it. In 9/11, I had the statutory authority by Congress to give everybody the same amount of pain and suffering. We all suffered $250,000 for the death of the victim. Airplanes, World Trade Center, Pentagon. And in addition, $100,000 for each surviving spouse and dependent. Add that standardized formula, which is not the tort system, to the economic loss suffered, which is the tort system, and that hybrid is used to attract people to take, on average, $2 million on average for a death.
One of the very important qualities of what you have done, and you discussed this, is you've combined the rigorous analysis, clarity, and efficiency with humanity and compassion. Are these compatible? How do you do that? How do you communicate to people, yes, I hear your story? How much do people want to tell their story?
I'm not sure how compatible it is. Once you have the plan in place, you become a shrink. But I must say, One of the great attractions of all of these programs, whether they're alternatives to the tort system or whether they're a gift, like One Fund Boston, giving people the opportunity to be heard. This is right up Bob Mnookin's alley. Giving people the opportunity to be heard. Let them vent. People don't come to me, ever, to talk about money. Never. The money is the money. There are formulas. People understand the formulas. They come for two reasons. Either to vent about life's unfairness. Nothing to do with money. Mr. Feinberg, I lost my daughter in the World Trade Center. She was a wonderful little girl with her whole life ahead of her, and now she's gone. There is no God that would allow this to happen. And you just listen. Or people come to validate the memory of a lost loved one. I lost my husband. He was at the World Trade Center. We were married for 25 years, and I want to show you a video of our wedding 25 years ago. I want you to see what those murderers did to my husband. That's what's tough. That part.
Yeah.
Whenever you take on one of these assignments, brace yourself. Just brace yourself. That's the tough part of the job, the debilitating part of the job. But it's very important that people buy into the program, and that's how you get them to buy into the program.
So this is part of the greatest quality of human nature, is that even in the face of tragedies, we can summon up compassion, we can come up with some way, a ritual, something human. Now go to the dark side. How have you dealt with corruption, people claiming things that they're not entitled to?
With death claims, you guys know this from studying civil procedure and criminal law. Death claims, it's pretty difficult to commit fraud. Death claims. You know, here's a police certificate that the person died in the World Trade Center. Here's a airline manifest. They were on the plane. Here's here's military records from the Pentagon. Pretty hard. Injury, easier. BP was a problem because BP was an economic loss case. It wasn't really a death program. BP, remember, with the oil spill, the fishing grounds were closed, so everybody's filing claims for business interruption and economic loss. And when you tell people, well, prove your loss, they go, well, you know, we do things with a handshake down here. No, you're not. Well, I'm not paying you a handshake. So fraud there. We had about 18,000 suspicious claims. Now, that's nothing. We had 1,200,000 claims in BP. Wow. I had 200 claims from Massachusetts. I didn't know the oil got up to Massachusetts. 200 claims from Massachusetts. 35 foreign countries. I had claims from Nigeria. So...
And as I understand it, in the BP case, the question about where you stop the line of economic loss is also hard. How about the motels for the people who were coming to participate in the part-time seasonal vacation?
You know what I did?
What did you do?
You had to decide eligibility. What about motels after the BP oil spill on the beach versus hotels inland? How do you decide? I'm no fool. I retained the services of John Goldberg. Who better than John Goldberg to write this 15-page memo on the scope of the statute that covered oil spills in the Gulf of Mexico? And that laid out, it was like tort 1 final exam for you guys. It laid out how you go about deciding the scope of proximate cause, or the equivalent under the statute. And, you know, all of the criticism I directed to Harvard, so it went down very well.
So I have like about 4 more questions. In the Agent Orange example, you had a court proceeding going on, and you had a judge who wanted a settlement. What is the right role? What role did you play in pushing along a settlement where actually the law might not have been there? Should there be a settlement process that gets the parties to a table?
Well, you know, that's a big debate. the scope of judicial activism. Now, in Agent Orange, the nation's foremost activist is Judge Jack Weinstein in the Eastern District, federal judge, appointed by Lyndon Johnson, who John Goldberg clerked for. And Judge Weinstein is still sitting. He's 95 years old, still sitting in Brooklyn.
And writing about evidence.
And still writing about evidence. And the judge felt very strongly that his role was to try, if he could, to end Vietnam veterans' suffering by coming up with some degree of a settlement that would close the chapter on Agent Orange. So he appointed a special master. He I was the puppet, really. He was the one who issued I think, very sensible rulings that impacted the leverage of each side. And the Second Circuit, go read the Second Circuit's review of Judge Weinstein's opinion, where they say, by a vote of 2-1, we approve the settlement, this very creative settlement of Judge Weinstein. Don't ever come back here with another case like it. Well, they did, Judge Winter. And I think it was the right thing to do. Obviously, I was very much involved in that. That was the first example of my taking my law degree and trying to divert it into an area that I never, ever anticipated would be what I would do with my legal career. And from that moment, Agent Orange, that one case, that changed my entire career.
So one comment on that, and then I want to hear more about your career and your steps along this unusual journey. From what we now have seen in the intervening decades, many of the unclear evidentiary questions and even legal questions pending in Agent Orange have gone in a way that would have affected the plaintiffs. They could have gone in the opposite direction. So there's a kind of godlike quality in creating these alternative systems. It's kind of out of time, out of space, out of facts. Is that a lot of responsibility?
It is a lot of responsibility. First of all, it's not done very often. Don't kid yourself. Agent Orange, 9/11, GM, BP gets a lot of play. You can put these alternatives on two hands, maybe one hand, really. This is not the wave of the future. If anybody thinks that what I do is the wave of the future, these programs are better studied, I think, in history class. I don't think they have much precedential value at all. Not really. Maybe you borrow from them a little bit, but I don't think they have much precedential.
Well, not precedential value in the way that law works, but a model, the same way that in my field of international criminal law, a Truth and Reconciliation Commission in South Africa becomes a model that other countries then want to copy. And they don't pick it up and replicate it exactly, but it gives people an idea that you could build a different institution than anything that has existed before to deal with something that's very hard.
I think the American litigation system, Bill's the expert, but I think the American litigation system is so ingrained in the history of the country, the heritage of the country. It's not going to change. I mean, if somebody gets hit by an automobile here on Mass Ave, you hire your lawyer, I'll hire my lawyer, and judge and jury will decide. And that's the way it's going to be. I think what I do is very interesting. It's very challenging. It's very rewarding. It's more rewarding than anything I thought I would do with my law degree. But it is not anything that I pass on to the next generation. And don't forget, no one talks very much about, these programs tend to work. They achieve their objective. But as the dean points out, you are delegating to one person all of this responsibility. I mean, administrative law professors must recoil in horror at what I do. There are no committees, no appeals, no checks and balances under the guise of efficiency and speed and consistency. This is what's done without any worry about, well, wait a minute, do we want to have one guy do all of this stuff?
So let's talk about your career. I mean, you're practicing law, you have a great thing going, you get involved in the Agent Orange case, you go a different path. What happened, why, and how?
Why? Pure serendipity. I mean, if you think you plan, I'm a very good example of why law students should not plan more than a year or two ahead. Life has a way of changing your best laid plans. Judge Weinstein and I had clerked, John knows the story, Judge Weinstein and I had clerked for the same judge 30 years apart. He's 95, he's a little older than I am. And we both got to know each other as law clerks. Alumni dinners every year with the judge. And when he was appointed and had the Agent Orange case, he asked me to mediate that case. Judge, I've never mediated a case in my life. There's no mediation classes at the time at NYU Law School. Doesn't matter. You'll do fine. And we got it done. And after that, changes your life. So I'm a little dubious about planning
Yes.
too far ahead. If those planes hadn't hit those buildings in 2001, I wouldn't be doing what I'm doing now.
As you think about, you've done quite a number. How much are you refining a model that you've used before? How much are you building something brand new each time? And who else do you bring into this?
It's the same every time. You do one of these programs, whether it's an alternative to the tort system or not, ask yourself the same 6 questions. We talk about this in my reading class this semester. It's the same 6 questions. How much money do you have to distribute? Based on that, who's eligible? What's the methodology for calculating damages? What's the proof you want from each claimant? Should there be some due process protection, a hearing? And do you need a release or no release at the end of the process? 1-page sheet. It's not, you don't refine very much. You don't refine very much. I farm out if I need infrastructure. I farm out the work. I may need a law firm. I may need a accounting firm. I may need a claims appraisal firm. I may need an anti-fraud unit. So I'm a patronage dispensing machine because I don't do this. I may need consultants like Goldberg, and that's what you do.
And what about on the compassion psychology business?
I'm not in the
just
psychology business. No. Now, people say, wouldn't it be helpful to have a psychologist? First of all, you'd be surprised at the resistance you get from claimants, if you're even going to suggest it. For myself, I don't use a psychologist. I have my own. I have other ways of trying to maintain my sanity, but it's not with a psychologist. So, you better have a loving family. You better have some outlets to keep you sane when you hear these stories about terrible loss.
Yes. Well, I was going to ask you a question, and not to get too personal about it. You have heard terrible, terrible things. What do you do with that? Can you compartmentalize? Do you need to show compassion? What do you do?
First of all, you become a very good listener. There's nothing you can say when you're dealing with people who have suffered traumatic tragedy. There is nothing you can say that is going to ameliorate. You try and listen and empathize, but you're a sounding board more than anything else. And what you try and do, you can't compartmentalize it. It stays with you. And it's debilitating. So you try and divert. If I'm listening to families and I'm having hearings with families lamenting what's happened to them, well, you may listen to 3 or 4 of them, and then you better go for a walk around the block and buy an ice cream cone and watch little kids playing in a park, or you'll go mad. It is very, very difficult.
Well, I just don't think we should let a minute pass without acknowledging you are giving people an enormous gift of your listening capacity and your presence. My last question, and so pretty soon I'm turning to you, so get ready. Get ready, it's about to happen. I want to ask a little bit about the rest of your life. I mean, you have a wonderful family, but you also do a lot of public service. You're involved in the John F. Kennedy Library. Can you say something about what a good life is like with a law degree where you don't practice law, but you do a lot of things?
I was lucky. I grew up in Brockton, Mass. And I grew up at a time as a teenager when the President of the United States was a fair-haired son of Massachusetts.
With your accent.
That's right. My car is parked right outside. And President Kennedy had a profound impact in my life. President Kennedy said at the time, public service is a noble undertaking. Every single individual can make a difference. Government is not a dirty word. And the public interest should be served. I must say, it may sound cliche, but it had a profound impact on my outlook. I thought that my law degree would provide me some flexibility. I always wanted to be a lawyer, at least from college on. But I thought it would give me some flexibility. I never, ever suspected that it would give me this type of flexibility and this opportunity to do something so out of the box. And I believe that I'm proud to be a lawyer, and I think our profession, I must say, for all the criticism we get, I think the legal profession, at least in the areas where I've been working, has stood real tall and should pat itself on the back for the work that not just me, but others who have helped, have really helped change people's lives. And I think that makes you sleep at night.
That's great. Questions, comments? Bill Rubenstein. We have a mic coming. Great.
What's that? Is it on? I don't have your booming voice, but I have two quick questions. One is just a very quick question. You said you can count on one hand how often this happens, and it strikes me that with BP and GM, where you have real defendants with money, in almost any disaster like that, they're going to have some kind of claims facility. So it strikes me that kind of stuff happens pretty often. The only distinction is whether you're involved or not.
Well, that's a big distinction.
Yeah, I agree. That's why I made it. But I think what happens rarely is the terrorism and the 9/11, and kind of wanted to see if you agree with that. But here's my real question. On the empathy side, I'm wondering the extent to which what you do, courts could do better. And my question is this: when you do it, the person has to be talking to you, not anyone on your staff, correct? So in the analogy, they'd have to be talking to the judge herself or himself in this situation. And could courts incorporate some aspect of that where maybe at the beginning of a case, the plaintiff got to tell their story to the judge? And you suggest that might make a lot of everything else go away after that point, or make things easier.
Could they? Could courts do what I do? Sure. Will they? No, I don't think. I mean, there's no evidence that I see that Judge Weinstein does it. But I mean, isn't that rather an asterisk? I don't think that as a general rule, federal judges steeped in the law, appointed by a senator, nominated by a president, confirmed by a Senate, take to the bench. I don't really think that you'll find much in the way of empathy or that type of one-on-one empathy. And in terms of your first question, BP, don't big corporations with money do this all the time? I guess they do. But there's a substantial difference between BP fronting $20 billion, saying, we agree with President Obama, let Feinberg set up this program, we'll have nothing to do with it except pay for it. We're out of it. And he can do this. Or GM, the same thing. Congress wants us to set up a fund, we'll have Feinberg do it, and we're getting out of the way. That's very different than a company settling a mass claim, trying to do it with a class action or an MDL or some other way. I mean, it's a different I think it's different in kind, not just degree. I agree with the fundamental proposition that most companies settle most litigation at some point during the process, yes.
Next. Comment, question. Please say who you are.
Hi, Professor. Stephen Anstey. I'm a student in your reading group. And you... You often talk, and to go off Dean Minow's point and the question that was just brought up on the importance of talking to your clients, so the importance of lawyers talking to their clients, how it's essential, especially in the cases you deal with, but even from their complex litigation, class action litigation. But there's also a cost to it, and you explained that to us with great frequency, and it is terrible. Is it important enough that it should be structured into complex litigation, into settlements, into cases that deal with those kind of issues?
If you're asking, is there some better way where lawyers communicate with their clients in mass cases? Now, I'll bet you Bill Rubenstein spends 1 or 2 classes on this. This is a very good question. Put it another way. How do we promote the notion that in mass claims litigation, the lawyers who purport to represent class members or MDL participants actually, like the lawyer who's hired if there's an automobile accident, actually communicate and actually inform the class and these individuals so that they're educated about this? Now, this is a big issue, a very big issue. One Journal of Columbia Law and Social Policy a few years ago dedicated to Judge Weinstein. John may have participated. There's a series of articles dealing with this question. How does the federal judge with control over a huge number of people help the lawyers, demand that the lawyers promote a better one-on-one relationship in communicating with their clients? It is a huge problem. Technology helps in terms of conference calls, in terms of live video conferencing, in terms of outreach, town hall meetings, etc. But it is a big problem, which results in some judges who might otherwise be sympathetic saying, if you can't come up with a better way to make sure that the massive number of claimants know their rights and know what to do, we're not going to approve this consolidation. And it's a big issue. So it's good that you raise it.
Please just identify yourself.
Hi, thank you. My name's Sarah. I'm just a 1L, not in your reading group. My question's about the second question that you said that you asked, is sort of who's eligible. One feature, at least, that we learn in 1L torts is that the definition for sort of loss of life, who's able to claim for emotional distress, is a fairly narrow list of close, immediate family members. But obviously in America, a lot of sort of who we consider family is changing. I know 9/11 was before gay marriage, so there would be same-sex couples that couldn't be married but would have been. There's step-parents, there's step-siblings. How do you, in designing a system, think about how you should define who's able to claim for a loss of life?
That's a great question. And there's a simple answer. Is there a will? Did the victim have a will? If the victim had a will, we'll follow the will. Most people in 9/11, 2/3 of them didn't have a will.
Wow.
The law of intestacy in the domicile of the victim governs. I mean, what else can I do? Mr. Feinberg, in 2001, I'm the same-sex partner of the victim. No will. I want to be treated like a spouse. We lived together for 8 years. Biological parents of the victim, what do you think of that? An outrage. She's not entitled to anything. Well, she isn't entitled to anything under the law at that time of 48 states. Same-sex partner, I'm sorry. I can't solve the world's problems. Now, what I will do is I'll go back to the biological parents and try and use a Bob Mnookin tactic. I'll try and mediate. I'll try and negotiate. Biological parents, will you give the same-sex partner a third? Okay. No. No? Let me ask you this. If I add, in my discretion, another third in the amount of the award, will you agree that that be earmarked for the same-sex partner? Okay. No. There are plenty of no's. Well, at the end of the day, it's frustrating. What can I do? I'm not going to trump the law of intestacy in the state of New York. I've got to follow the law. That's the only way I can be neutral and say to people, this is the law. I got to follow the law. And all but 18 families in 9/11, we worked it out. 18, we couldn't work it out. I tendered the money into the probate court. Let them go fight it out. I'm not going to get in the middle of that. Terrible problem.
John Goldberg.
Thanks, as always, Ken, for a fabulous discussion. Thank you, Dean. You've described a lot of what you've done with words like alternatives to the tort system, and that's a kind of friendly way of putting it, but one could put it in a more adversarial tone suitable for lawyers in litigation, right? Which is you're taking away potentially a lot of business from both plaintiffs' lawyers and defense lawyers, and they have, not surprisingly, have views on this, and it's not just self-interested views, right? They have views, at least some do, of principle, which say it's important that claims be litigated and not settled in some of the ways that you've tried to settle them. And I'm wondering if you could just say a few words about how your interactions with the litigators and how that's affected the way in which you've approached your job.
Some litigators are very supportive. 9/11, as you know, the trial lawyers endorsed the 9/11 program and represented 1,500 victims pro bono. The 9/11 program would never have worked without the trial lawyers. They were fabulous there. BP, a lot of animosity. I'm closing out cases one after another in the Gulf of Mexico, and every case that I'm closing out, if the individual claimant doesn't have a lawyer, that's one less potential client. So it can get tense. Now, I want to say this about trial lawyers, about lawyers who represent clients. This notion, not really advanced by John, in fact, John was sort of making another point, but this notion that lawyers who represent clients in court are against what I'm doing because it's costing them money. I don't think that's right. They're against what I'm doing, some of them, but I don't think it's because it's costing them money. They're taught at Harvard Law School about the adversary system, the law of advocacy, our trial system, evidence, civil procedure, checks and balances, judge and jury. It's a philosophical aversion to what I'm doing. One guy delegated with all of this authority. What happened to judges, checks, balances, juries, appeals? There's a philosophic problem with what I do. And I think that concern is largely valid. It's largely valid. They're taught another way of doing things. So I think you try and get the lawyers on board, and you always do. I mean, I had plenty of lawyers who support what I did in GM and BP and now Volkswagen, but you're going to run into this philosophic tension. Now, sometimes people say to me, you prevent theories of tort deterrence, because when you compensate victims who sign a release, what happened to the notion that the tort system will deter through verdicts and punishment corporate wrongdoing? Now, I think that that's a very good argument, except in all of these programs, enough people opt out of my program so that theories of tort deterrence, I think, are vindicated. In 9/11, I said 97% of the families came into the fund. Well, 94 people decided to sue. 94, not 9 or 4, 94. I think that's pretty good tort deterrence. Now, they all settled their case. But I think that there's always going to be people, for whatever the reason, who opt out of anything that's being offered and decide, I'm going to litigate. And I think that vindicates theories of tort deterrence. 18 in BP. About 30,000 people are still suing. It's pretty good. One might say that's over-deterrence, 30,000 people.
Here comes the mic. Say who you are.
I'm George. I'm a 1L, also not in your reading group. We've talked a lot about systems and programs that have worked. I assume there are programs out there that haven't worked as well. And if so, what made them not work as well? Was it the disaster, the administration, the people, all of the above?
All of mine have worked. But I've done mass mediation that Bob Minow knows about in, for example, asbestos in Baltimore. There was a series of, I would say there were about, 8,000 asbestos cases consolidated. I was the mediator. Those 8,000 cases did not settle under my mediation umbrella. I think probably they didn't settle because we tried to settle them too early in the litigation. If we had waited another year until the cases were really teed up for a consolidated trial in the Baltimore city courts, I think we would have done better. And I think, if I remember correctly, the main plaintiff lawyer in those cases, representing the asbestos victims, was Peter Angelos. He eventually settled almost all of those cases, turned around and bought the Baltimore Orioles with the settlement proceeds. So he served the community very well.
One of the elements of your accomplishment here is to acknowledge that there are not just tragedies and misconduct that need some kind of process, but also that aggregating all together, is a way to handle these issues. And the tort system, the civil procedure system, they're not so great at that. It kind of, oh, I'm sorry, Mr. Class Action. They try, but it's not perfect. And I wonder if you think that there are other areas where aggregating the solution that we currently handle one by one might be useful, beyond the ones that you've seen.
Great question. Aggregation's key. I lament court decisions in recent years limiting aggregation, especially class action aggregation. Here's the guy to talk to on that, Bill Rubenstein. It's a problem. It's a real problem. If you can't get the cases in one forum, then you look for other ways. Creative use of the MDL, bankruptcy. Most of the asbestos aggregations are now in the bankruptcy.
Multi-district litigation for the one else.
Bankruptcy, local regional consolidations. Every time Judge Weinstein is told he can't do a class, he just consolidates in his own court and says, all right, no class. For 5,000 asbestos victims, you're all in one case. Here locally, not a class. So, I mean, you have to aggregate. One reason that policymakers look at BP or GM and like what they see is, I will informally aggregate the claims and set up a facility. Volkswagen. Right now, you'll see, in the next month, I think, you'll see some program, whether it's part of Judge Breyer in California or a standalone, you'll see some sort of aggregative system to fix these automobiles or buy back the automobiles with this emission problem. So aggregation, you're right, aggregation is key to all of this.
Bob Minow.
It's a follow-up, and that is, from afar, if you look at our legal system, asbestos, I too was involved at times as a mediator in asbestos cases. When one saw how the tiny amount of resources that ever went to victims and what was absorbed in terms of the transaction costs between the fights among insurance companies as to how they would share it, whether to aggregate or not, a huge problem, which, by the way, the systems that you've helped design mitigate, is how do we set up systems that are fair, that are reasonably consistent, that minimize the transaction costs of distributing money. And I disagree with you that that's an issue that is going to be rare and is going to go away. I think it's going to be a huge problem of this century. and how they're aggregated, if they're aggregated, what role courts are going to have. It's a big issue, and I think one of the dilemmas, we have this romance about the litigation system. If you ask litigators, how many cases have you actually tried? How often are you using evidence in court? Very infrequently. In fact, they're complaining about the disappearance of the trial, because things do get settled. They just often get settled very late. So I just wondered what advice you'd have for young people in terms of planning their careers, where they have an opportunity to be process architects, and as practicing lawyers with clients to think about how they can set up more efficient systems.
First of all, I'm not sure we disagree. I say that the type of program I administer and design, very rare. The issue, the problem you confront about inefficiencies and cost and delay, of course, that's an issue of the 21st century. I agree with that. Now, you're seeing more and more informal resolution. No one goes to trial anymore in asbestos. There may be a couple of aberrations. Companies set up these inventory settlements where every month, cash flow, every month so many cases will be processed based on agreed upon criteria, etc. So there are very creative efforts underway in certain mass claim situations to come up with something that is a better alternative than either trials or what I do, which is a very visible public aggregative program. So I don't think, you disagree with Mnuchin at your peril. I don't really think that, I think I probably agree with much of what he just said. Now, how you plan a career, that's another question. I mean, go talk to the guidance counselors. My only advice is, I gave it a little bit earlier, don't plan too far ahead. You'll get opportunities. You don't think they're there. Harvard? You'll have all sorts of opportunities to think out of the box, what Steve is up to with this whole idea of funding this program. It's fabulous. I mean, I just think that you have more and more alternative ideas. Either it's arbitration, get involved somehow in the design and administration of arbitrations, mediations. Court clerkships are fabulous if you get court clerkships with innovative judges thinking these thoughts.
And private systems. eBay adjudicated 1.2 million disputes last year without a single person, all using algorithms.
There you are.
That's next. Your talk includes these key words: unconventional and tailoring. Please join me in celebrating the unconventional but well-tailored Ken Feinberg, the Stephen and Maureen Klinsky Professor of Practice for Leadership and Progress. We are so grateful for your teaching, your inspiration, and your problem solving. Thank you.